reiterate today that sexual harassment is a serious matter and should not be taken lightly. It has harmful effects on its victims, be they men, women, boys, or girls. I repeat that these meetings in which we hear submissions from various organizations and members of the public are intended to improve the bill. Today we will hear from Jamaica Confederation of Trade Unions, the Jamaica Household Workers Union, the Soroptimist International Jamaica, the Association of Women's Organization in Jamaica, OJA, Woman Inc., as well as Jamaicans for Justice. I would like to remind the presenters that you have 15 minutes to make your presentation, and following on which there will be discussions. At this time, I just want to thank you all for coming and to look forward to your contributions. I'd like to ask MP Rhoda Crawford to bless us before we start our proceedings.
Thank you, Madam Chair. Let us pray. Eternal God, thank you for health. Thank you for strength. I thank you for taking us here safely. As we're about to deliberate the nation's business, I pray that you grant us additional wisdom, additional strength, patience, and tolerance. Those who are on their way, I pray that you will hasten their steps and have them arrive here safely. These and other mercies I ask and thank you for. Amen.
Amen. Thank you, Member Crawford. Just for the records, we have any apologies for absence? From Dr. Angela Brown-Burke and?
We also from Senator Natalie Campbell Rodriguez.
Madam Chair, apologies also on behalf of Senator Scott Motley.
Thank you very much. So on the agenda, you will have presentations being listed in a particular order. We're going to vary from that a little. And we will take as the first presentation the Jamaica Confederation of Trade Unions, Mrs. Eileen Davis-White. The president is here to make presentation, and we certainly look forward to this presentation, Mrs. Davis-White. Thank you so much for coming. All right, please proceed.
Thank you, Madam Chair. Madam Chair and members of this Joint Select Committee, I am indeed pleased to be presenting on behalf of the Jamaica Confederation of Trade Unions on this very important bill that we hope will be passed in a very short while into law, so that those of our members and members of the population in general who have been exposed to acts of sexual harassment, that they will feel that there is some justice to be had arising from the passage of this bill. We want to start off by noting that there was a long period of consultation before the bill was actually developed, and the Jamaica Confederation of Trade Unions was involved in several of those consultative meetings. And therefore, the draft that is before us, the bill that is before us, is something with which we find favor in terms of most of the clauses of the bill. But what we wanted to focus on is that since the bill was actually developed, we have had at the International Labour Organization the passage of, or the adoption of, Convention 190, which addresses violence and harassment in the world of work. And My colleague Shirley Price here and I, we were certainly there when it was actually being adopted, and it was in fact something that was quite exciting to see that we had gotten to that stage. What we felt needed to be done, the fact that Jamaica had actually supported the adoption of the convention, is to ensure that the sexual harassment bill that is before Parliament, as far as is possible, contains the various provisions in that convention to ensure that we would be able to get off the ground very early once we had actually ratified the convention, because Jamaica now has to ratify that convention. Ratification will mean that we will have to look at our legislation to ensure that the provisions of the convention can in fact be implemented, and that is usually through law, and we thought that the sexual harassment bill was in fact the vehicle that we could use to do that as quickly as possible. Once we looked at the bill, we recognized that there was an attempt to take that on board, but there are some other amendments that we would want to propose, and in terms of the bill itself, there are some other amendments that we want to propose as well. So, in terms of the amendments that the Confederation of Trade Unions is proposing, we would want to propose an amendment which would add a clause defining the workplace, because we recognize that there's really no definition of workplace as such in the bill. We have reference to worker and employer and work, but we don't have reference to workplace. And we recall that this was something that was a matter that had enjoyed the discussion at the International Labour Organization. Several countries belabored the point of what exactly is the workplace, and to ensure that the workplace was properly defined. And so what we have basically done here is to lift from the convention the definition of workplace, and we are proposing that it be added to the bill. And that clause says that a workplace should be defined as A, public and private places where they are a place of work, places where a worker is paid, takes a rest break or a meal, or uses sanitary, washing and changing facilities, employer-provided accommodation and transportation, work-related events, trips, training, and social activities, all of which would embody the workplace. So it's not just what we would think of as a workplace, but all these other concepts as well. We would also want an amendment that would specify that the law actually does apply to the landlord and tenant relationship, as is stated in the memorandum of objects and reasons. We don't think that it is properly defined in the law itself, and so we would want that to be clear, that it actually does apply to the landlord and tenant relationship, which we think is commendable because there are so many different examples and anecdotes of particularly women, but there are men too who have been exposed to acts of sexual harassment within that landlord and tenant relationship. The other thing that we would want to be done, there are several places in the Act where there's reference to the term reasonableness. And that term, by its very nature, connotes a subjectivity. And so, as far as is possible, we would want, wherever that term is used, that it be as clearly defined as possible, because what I may think is reasonable, another person may not think is reasonable, and then we would have, as a result of that, conflicts that could arise. So as far as is possible, we would want to take out of the law any reference to the term reasonableness. There is also a term that is referred to in this bill, person conducting a business or undertaking, which was a term that first came into certainly industrial relations jargon via the Occupational Safety and Health Act that is now before another Joint Select Committee. And it is used here in this act at one part, but we feel what needs to be clear is that it doesn't actually define person conducting a business or undertaking. There's a definition for employer, which does not refer to this term PCBU. But further on in the Act, there is a term used in terms of the definition of worker where it mentions somebody who is employed by a person conducting a business or undertaking. So what we would want to do to ensure that this term is properly understood is to make sure that when we are defining employer, there be reference to that term, and that in terms of the definition of a PCBU, that it should be made clear that it includes corporate entities, companies, partnerships, and employers as defined under the bill at Section 2, and should also include individuals exercising the authorities, duties, or responsibilities of an employer. So it is made clear that when we're talking about PCB, we're really talking about an employer, and that the use of the word person does not mean that it exempts corporate entities. So we want to make sure that that is clearly understood in the bill. Under the definition of worker, again, we have lifted terms from the Convention 190, and we are asking that it be amended, definition of worker should be amended to include workers whose employment has been terminated, as well as job seekers and job applicants. From my recollection of the discussions in Geneva, persons in these categories were, it was felt needed to be specifically mentioned because they would always be subject to acts of sexual harassment. We would also want for a mechanism that allows for complaints to be made directly to the authority established under the Act for investigations to be carried out. Our concern here is that the law speaks to an employer establishing and promulgating rules, guidelines that in respect to sexual harassment. But what we are seeking to look at here is that the process that exists in a formal kind of organization, where you have the employer who may be the owner of the business, somebody very high up, and you have persons going through the line from supervisors going up. In the case of persons who are in informal employment, that kind of structure does not exist. And so very often these persons may have to be reporting to the very same person who has committed the act, that this act has taken place by virtue of how it has it is set out. So we want it to be clear that anybody who is feels that they have a complaint for sexual harassment, that individual can go directly to one of the officers so appointed to make that report, and the officer would have to investigate, because getting to the tribunal, you have to do that by virtue of how we have read the bill, to get to the tribunal through the officer. And so we are saying that it must be made clear, especially in relation to workers in informal employment, which would include our persons in domestic work as well, that they would have that ability, and they would know that they can make a complaint to an independent authority, and that independent authority would be empowered to investigate and take it as far as the bill allows. And so it goes on now to us seeking to have in the bill the actual process. It may not be in the bill, it may actually be in the act, it may actually be in the what do you call it again? Regulations. It may actually be in the regulations, but we are saying that you need to have established a process for making and handling complaints, which should include reporting companies directly to authorized officers who have been established at Section 10(1) of the bill, particularly for persons who are employed in the informal sector and those employed on fixed-term contracts as well. Our other amendment that we are seeking is in relation to Section 10(3) to amend it to make the period for compliance with the direction of an authorized officer to be, instead of not less than 30 days, not more than 30 days. So we are saying that's the outside limit. So for the person, this is where the authorized officer has investigated and is saying to whomever, the employer, that you should do something. And we are saying is that they should have a maximum of 30 days within which, and not, so instead of it saying not more than 30 days, not less than 30 days, we are saying that it should say not more than 30 days. Section 11, the amendment that we are proposing here is in respect to the how the tribunal should be named, and our amendment is to seek to have the provision for one member each to be named by the Jamaica Confederations and the Jamaica Employers Federation on the tribunal, similar to what obtains with the Industrial Disputes Tribunal. To include at Section 19 a provision to disqualify any person who has been found guilty of prior acts of sexual harassment. And Section 25(2), we are seeking to amend to provide for a longer period for a complaint to be made after the alleged contravention. And this we know is a point that has been raised, and there are varying views. We have not actually put in our submission the period of time that we are indicating, but what we have looked at is a period that would be similar to what most Jamaicans refer to as a statute bar, which I think is 7 years. And one of the reasons why we are opting in that direction is that if we look at institutions, including schools that which may involve younger children, for that reason we believe that you need to have a much longer time than what is proposed here, because in those situations, very often the evidence is that persons who have suffered sexual harassment in those situations may not actually bring it out until much later, and sometimes after they have left the institution. And so we believe that it should be more akin to what is that 7-year period rather than what is proposed here. And in terms of the process that the tribunal should observe, again, possibly in regulations, we believe that that should be clearly stated as a process to be employed by the tribunal in dealing with any complaints that come before the tribunal. So, Madam Chair, members, that basically is the submission from the Jamaica Confederation of Trade Unions, remembering, as I had said before, based on the consultations that had been had over the several years, when we looked at the bill, it included most of the things that we would have asked for over the years. So it is just these areas that we would really want to have tidied up, so to speak. And so that basically completes our submission.
Thank you so much, Mrs. Davis-White. Member Chuck, Minister
I
Chuck.
just want to help you with one correction. You use the term reasonable in legal terms is objective. In other words, you said reasonableness or reasonable means subjective. How lawyers use the term reasonable, like the reasonable man, is not subjective. It's very objective. In essence, when you speak of reasonableness, I agree with you. People have different concept of what reasonableness is. But to the court, who is the reasonable man, say, in Santa Cruz or Port Antonio? Or if in fact it's, say, a butcher who causes a killing. The question is, the reasonable man could be, who is a reasonable butcher? Not necessarily the butcher who did the killing. So if you don't use reasonable, then it is the butcher who did the killing and not necessarily the objective standard of a reasonable butcher. Okay? Just a correction.
Thank you, Minister Chuck. Senator Gale?
So, Chair, you are permitting me to ask myself some questions. Mrs. Davis-White, you made reference to C-190 Convention, and I believe you made some inclusions in the definition for workplace. And Article 3 of the Convention makes reference to through work-related communications, including those enabled by information and communication technologies, which was not included in your definition. But you would have had other groups submitting that because in the advent of COVID-19 and the workspace has changed, the inclusion of communication and technology plays a part in where they can face or be impacted by harassment. Would you be prepared to agree to include that in your definition? And the other one, when commuting to and from work, and I'll give you an example. You have some group of workers who, by virtue of their functions, they have to be picked up or drop off to work. So the company provides transportation. And in another bill that is under review, it takes into consideration that as a place of work. So would you be prepared to include that in the definition? The other area that I just want some clarity on would be under your submission 5, where you indicated workers whose employment has been terminated. Now, I make the assumption that a worker who has been terminated and another scope of another legislation, the LRIDA, would be treating with that matter, possibly at the Ministry of Labor and the Tribunal. Are you suggesting that that worker could face possibly harassment as an inducement to forget this issue of sexual harassment? And so you are including there that component where workers would have been terminated. And the last clarity that I would seek is in your point 12, where you made reference to section 29. If you could elaborate a little bit more on the specific process to be observed by the tribunal, because we know in the LRIDA there's a very lengthy, detailed process that has been established in how the tribunal should operate. Is that the same focus or application that is being submitted here? Those would have been my comments.
Thank you, Mrs. Davis-White.
Okay, in respect to the first, which is about the definition of workplace, I would agree that all of what is in Article 3 should be made to apply. Trying to remember why we had only mentioned some, or is it that we had joined? But our thing was just to lift Article 3 and put it here because there was really no definition here. So we would agree that everything under Article 3, including work-related communication, because especially now that we are in COVID-19 and everybody is communicating not face-to-face, well, a lot of us not communicating face-to-face, that the sexual harassment can in fact take place using the technology. So I agree that those should be added as well. The other was in relation to definition of worker, where the thinking was, if I recall, and this comes from the discussion at the ILO, was that a person who has been terminated, who may want back their job, may be subject to harassment because they would want to, they could be tried to be told, do away with it at the tribunal, and I will, if you do X or Y kind of thing. So yes, that is the thinking in terms of including workers whose employment has been terminated. The other was in relation to section 29. And no, we did not have a specific process laid down, but what was our concern is that it should be a process that would not necessarily require the individual, that should reflect what would normally be there in terms of you know, persons being given the latitude to present evidence and witnesses and so on, but that in terms of the formality, it should not be as formal as that, although we recognize that it is a serious complaint. But what we have found, and certainly in establishing the Industrial Disputes Tribunal, one of the reasons why it was felt that at the time, rather than having people just having legal representatives, that you had to have a process that persons could utilize other persons. In dealing with that, it would be a quasi-judicial process, but not as stringent as is the normal process if one were to go into a court of law. That is our thinking. So we did not actually have something that we would have set out in terms of section 29, but we believe that that process needs to be spelled out. And you know, the usual thing when we are dealing with bills is to say that we will deal with some things at the times when the regulations are being developed. And very often regulations don't actually follow the law. And this is why we felt we needed to mention it here, that the regulations do not take a long time to be developed, and that they should be promulgated as soon as possible after the law is passed, so that in terms of the process and how people can access and so on, all of these things would be made known, and it would not be something that sits and waits for an inordinately long time.
you permit me, please. Point 6, informal employment. Now, I assume that this is where you may have someone who have a contract for service with an organization, so there's no direct employer.
Or you may have direct employer in that, when we're speaking informal, I mean, the records show that in Jamaica, we have more persons in informal employment than we have informal employment. What we're thinking of is I just get somebody off the street to come and do a job of work for me. I am, to all intents and purposes, the person's employer. It may also be based on how we conduct our relations in terms of hiring domestic workers and so on, that yes, you have an employer, but the employment is informal because certain things do not exist. And so what we're talking about, not necessarily only in relation to persons who are on contract, but just how the work relationships exist when we have anything. As an individual, if I'm employing a gardener, I have the same gardener for 20 years, but it's in informal employment. You don't collect and you don't do the statutory deductions. There is nothing that says that this person has been employed to you for how long and so on. Those are the kinds of things that exist in the Jamaican space, why we believe it is important to take account of informal employment when we are looking at sexual harassment.
Thank you, Mrs. Davis-White. I'll take Ms. Georgette Grant, after which I'll take MP Crawford.
Thank you, Madam Chair. Thank you very much, Mrs. Davis-White, for your presentation. I too would like some clarity based on 2 points that you mentioned. You spoke to the complaints mechanism for a domestic worker, for example, and you gave your suggestion. And I was prompted to go to clause 25, subclauses 4 and 5, which speak to the tribunal granting leave to a person to make a complaint in instances where either there are no internal mechanisms or for the person to say, if I am to use these, I'm likely to be prejudiced. So I'm thinking, as it relates to the domestic worker, this would fit squarely within that situation. So there would be no internal mechanisms because, as you said, it's an informal relationship. So such a person could, with the tribunal's leave, go directly to the tribunal and show that I don't have these internal mechanisms, so I'm coming straight to you. And so I wanted to know if that's sufficient. And the second thing about a clause being added that the law will apply to landlord and tenant relationships. In clause 9, it speaks to sexual harassment in relation to accommodation, and though it doesn't expressly use the phrase landlord and tenant relationship, it speaks to accommodation being provided or offered, whether by the principal or the agent. When I read the section, but then that's me, when I read the section, I get landlord and tenant relationship from that, either from the principal or even the agent who then steps into the shoes of the principal. So I wanted to know, with those 2 clauses that I have pointed out, if the suggestions would still be necessary. Thank you.
In respect to the clause in section 25(3), one of the reasons why we felt it important to make the submission is that 25(3) speaks to it says, subject to subsection 4, a person shall, before making a complaint under subsection 1, exhaust the use of any internal mechanisms and procedures that are made available to the person as provided for in the policy statement issued by an employer or a person in charge of the institution, as the case may be. And so we were really looking in the informal situation, there would be no policy statement as such. And so for that reason, we felt it was important to put it in. We noted that the tribunal, at subsection 4, it said that the tribunal may grant leave to a person to make complaint in the circumstances provided in subsection 5, notwithstanding that subsection 3 has not been complied with. But we felt it was wiser in our view, based on how that this law is going to be have to be understood by persons who do not have any legal training or experience or so on. And the way it is written, you have to go from one back to the other, whilst if it says up front that anybody can make a complaint to an authorized officer, it's clear to that individual. They won't have to go to this and then back to that. So that's the reason why we felt it important to have it as a separate statement, so to speak, that the individual, every individual has the right to make a complaint direct to the authority.
So is it that you, for these informal individuals, is it that you have identified in your mind that there may be some gap in terms of how they get to the tribunal or how they get to the authorities? Having clearly understood that where there may be employment to a business, there may be a process, but for an individual in an informal aspect of it, is it that you want a prescribed medium to get to the authorities? That's what you're saying? Yes,
and we are saying that if it is made clear and is there, the individual won't have to be interpreting because it is clear that that is the case.
Thank you. Senator MP Crawford and then Senator Morris.
Thank you, Madam Chair. Mrs. Davis-White, thank you for your presentation. Very early in your submission, you mentioned the need for a definition of the workplace to be included. I fully support that recommendation. However, in the interest of clarity, I noted where you listed several elements that constitute or could constitute a workplace. I wanted to know if you meant that all the elements you read, if that was to be included for an area to be regarded as workplace. If not, from your list, what are the ones that you deem compulsory that needs to be included to be considered a workplace in the definition?
To be truthful, having responded to Senator Gale that we wanted to have basically all of them included, our thinking is that because of how the world of work is changing on a daily basis in today's economy, in today's world, there's this constant discussion about what is the workplace, what is work, and so on. We believe that all of what is there is in fact deals with almost every possible conception that one could have of a workplace. And this is why I responded to Senator Gale that we would want those that had been excluded from Convention 190 in our submission that they be added. So I would not want to be put in the place of having to choose which one to leave out.
Thank you, Mrs. Davis-White.
Senator Morris and then Senator Longmore.
Thank you, Madam Chair. Just two things. And before I start, I think that there were some thoughtful recommendations, very salient. But I think Ms. Grant had mentioned before the place of the clause that includes landlord and tenant. I just wanted to understand fully, is it that you're asking for a definition of the terms, or is it that you want clause 9 to be more explicit in stating that it's accommodation provided by a landlord to a tenant. And 2, I noticed that you stated that you're in favor of an increased time period for reporting, for making a complaint in, what's this, recommendation 11. Could you suggest a time period that you have in mind or that you think would be sufficient?
As I said before, what we were actually looking at is that is a 7-year time frame in keeping, and forgive me, I'm not a legal person, so I am using the terms that I am accustomed to, statute, bar, and I'm told that that is about a 7-year period. We are looking at something like that, and we are saying that because of the fact that when you're looking at institutions and you're dealing with younger children, it may take them that long to be able to come to a position that they can, in fact, make a complaint. I mean, when we had the case of the pastor in St. Elizabeth, I found, one of my members found that her daughter, who had experienced a similar kind of abuse, this is now like 15 years after she's now an adult. It is that brought it back for her, and it was that allowed her to be able to make it. So we are saying that it should not be something that is indeterminate, but based on the fact that it is covering institutions and will therefore have to apply to younger children, we believe that 7-year period would be a good period to put in the act. With regard to the landlord-tenant, what is our thinking is that, usually when you take up a bill, when you go through the definitions and so on, and you read the memorandum and objects of reasons, it gives you an appreciation about the bill itself. And there's no definition for landlord and tenant, although it is this particular section that is there. But one of the things that it doesn't say, it says offers accommodation. Some people may take that to mean not necessarily offer it for a price in terms of a rental or lease agreement. And so that being the case, we believe that if you can make it as clear as possible, it would be best.
Thank you. And Senator Fraser-Binns, Senator Longmore, and then Senator Fraser-Binns.
Thank you, Chair. Thank you, Mrs. Davis-White and Ms. Price, for your presentation. Really very useful and helpful. Just 2 quick points. The committee knows my concern around Clause 25.2. And just to put it in context of not just being children, it's also adults who have repressed memories, who sometimes have to cope, and you don't know when such memories may resurface, etc., etc. So we have many discussions around such time frames that we would want to consider. I just want to go back to the definition of the workplace in terms of what is your consideration around cyberspace and work that occurs in the virtual world, and how would we incorporate such concerns in this?
I think it would be included under the section that Senator Gale indicated that we had omitted.
Sorry, I had stepped out.
From the convention. The convention speaks to work-related communications, including those enabled by information and communication technologies.
Thank you. Senator Fraser-Binns.
Thank you, Minister. Thank you, Mrs. Davis-White, for your presentation. I came in late and I apologize. And Minister, let me, in case it was not done, apologize for Senator Scott Motley. She will not be able to make it today. Thank you for your presentation. I want to turn your attention to the 5th point in your submission. And Senator Gale gave an interpretation which is quite different from the one I had, because my thinking, and I just want to clarify exactly what is the thinking of the trade union movement, because my thinking is that you wanted that specific provision to include workers whose employment has been terminated, particularly because once they have terminated, they're not deemed workers, they're former workers or ex-workers, and they too, I understand, would have a right to bring an action even after the employment period. And that was my thinking when I heard you speaking, but Senator Gale said something was a little different, so I just wanted some clarification in that regard. Secondly, at 5B, I support the recommendation for the inclusion of job seekers and applicants, because in the bill we speak about apprentices, but we did not speak about applicants, and I think that is a very useful inclusion, because we do know that in the interview process, promises and advances can be made, and so I welcome that recommendation. The third thing is that the first point, 1A, when it speaks to public and private. By the way, I do support the inclusion of these recommendations at 1. 1A speaks to public and private spaces where they are a place of work. And I recall some time ago, the last term, there was a discussion about what happens in the virtual space and you know, the reality of some persons. And I wondered whether in your contemplation you envision virtual meetings, virtual work to include in section 1A.
We just thought that the convention, Article 3, which is basically what we said we have lifted and put here, that section D of the convention, which speaks to work-related communications and virtual meetings and so on, would be work-related communications, and it says specifically including those enabled by information and communication technologies. So I think that clause would cover everything in the virtual space, I believe. The other point about the worker who has been terminated, I think both interpretations are in fact correct, because we are looking at the fact that if somebody is terminated, there may be questions as to whether that person is still a worker and therefore has the right to make a complaint afterwards. But also, that person who has been terminated could be subject to sexual harassment in an attempt to get them not to proceed with the particular complaint. And so I think the two city scenarios, both by Senator Gale and yourself, would apply in that situation.
Just to say, just to say though that the Industrial Disputes Tribunal recognize the term aggrieved worker and contemplates that there is the possibility that that worker may resume their duties, so they are still recognized as a worker, not the fact that they are terminated.
Sorry, thanks for that, Senator Gale. Mrs. Davis-White, just a follow-up, because... Sorry, Mrs. Davis-White, just a follow-up to the explanation. I know counsel for the ministry asked whether the provision that speaks to reporting directly to the tribunal, whether that provision was sufficient in light of your recommendation at 6. But listening to you, I wondered whether the idea or part of the reason why you made a recommendation at 6 for direct reporting to the tribunal is to cover persons who would be job seekers or job applicants or persons who would have been terminated. Because one may not feel comfortable going back to the HR director or whichever unit for their former place of employment to say this happened, and perhaps just not trusting the system. And so even though there may be internal
policies and procedures at that particular place of employ, the comfort level of the aggrieved person may not be, the person may not have the confidence and so would want to report directly. I just wonder whether that was part of your thinking, and if it is, then I do believe that that is something that we can consider to have a specific provision, notwithstanding subsection 3.
And I agree with what you have said, and at the same time, what we are also looking at is the employer-employee relationship, which is very informal, and very often it is the employer who you are dealing with directly that you are going to report. And so clearly you have to have it made clear to that individual that they have the right to go direct to make the report, because we think the way the clause is stated, it almost assumes a kind of formal work relationship. And we are saying that there are so many informal work relationships in Jamaica that it is important to make that distinction.
Pretty much like what happens now, if somebody has an issue, they can go directly to the Ministry of Labor instead of going through the HR department.
Right.
Okay, thank you. So I think we have exhausted questions at this point, and I want to thank Mrs. Helene Davis-White, President of the Jamaica Confederation of Trade Unions, for her presentation, and to indicate that we will take your recommendations on board when we come to deliberating the final decisions regarding the Act. I now invite Ms. Shirley Price, President of the Jamaica Household Workers Union, to make her presentation. And I should indicate that there's an updated version of her presentation, which you will find on your, by your seat on the desk. Thank you, Ms. Price.
Madam Chair, members of this committee, all, good afternoon. My submission is coming from the Jamaica Household Workers Union and also the Association of Women's Organization in Jamaica, AWOJA. The Jamaica Household Workers Union welcomed the opportunity to make this presentation to this joint committee of Parliament on the Anti-Sexual Harassment Bill. Private homes are the workplace of domestic workers, the majority of whom are women. This work environment makes domestic workers live in, live out, or days workers especially vulnerable to sexual harassment, abuse by employers, their relatives, and friends. The majority are informal workers with no formal contracts. Even though there is some legislation to cover domestic workers, most are not enforced. With high level of unemployment, especially since the COVID-19 pandemic, domestic workers are especially vulnerable to sexual harassment in the homes of their employers. Labor inspectors do not have access to monitor working conditions in this private workspace, which makes it even more difficult. The amendment bill therefore needs to take these factors into account to address the needs of domestic workers. We have started a series of anti-sexual harassment sensitization workshops through the Bureau of Gender Affairs, the International Domestic Workers Federation, and the USHERA Labor Studies Institute at the UWI Open Campus. We are also supporting the research work done by Mr. Danny Roberts from the USHERA Labor Studies Institute and Dr. Simon Black from Brock University in Ontario about the compliance with ILO Convention 189 and providing decent work for domestic workers. Sorry. The Jamaica Household Worker Union also adding our voice to what President White says, that there is no definition for workplace. So we are saying that in a definition, it should be specifically included private household. This is so because workplace and working environment of domestic workers, are very different compared to those of other workers. And, as such, this is very important to consider, as when the law is passed, we want it to be very inclusive. We want it to work for domestic workers. We don't want it to be left out. As now, when you talk about domestic workers, and they say they're not workers because they work in this private household, and a person cannot call their household workplace. So this is what we are encountering right now. We are asking that to extend the scope of the bill to include not only employers, supervisors, co-workers as perpetrators of sexual harassment, but also sexual harassment by employers' relatives and even friends. Domestic workers, particularly those who live in with their employers, sometimes face the threat of sexual harassment from employers' relatives and friends who happen to be living in the same household or even come visiting. I know that very well. I can give you many examples of that. I was a domestic worker for 31 years, so I can speak to that. And I've got a lot of complaints in our union as well. Increased penalty for sexual harassment. The maximum penalty should be sufficiently heavy for persons who are found guilty to serve as a deterrent for would-be harassers. The law sees harassment as a civil matter, but it should be classified as a criminal matter, which would increase the penalty and would be more effective as a deterrent for the perpetrator. They would think twice of doing the act. We support the call for an extension of the time given for victims to report the cases of sexual harassment. 12 months is too short when you consider the psychological trauma the victims experience. We're proposing the establishment of a registry for sexual harassment offenders who have been found guilty by the tribunal. The bill needs to ensure the creation of a safe working space for all workers within and outside the home. We need a place free from all violence and harassment. This is what we are calling for. Chair, if you could just allow me a few more minutes, I want to touch a little and fighting for this Convention 190. It was in 2018, before going to the ILO, we launched our Time Come campaign at the Brighton New Testament Church of God. Director Robinson was there to represent you, Minister. We were saying time come, adoption for Convention 190 now. We went to, Miss Ellen Davis-White is here, we went to Geneva. We fought. I myself was there with my book, and we marched the street in Geneva just to be heard. Minister, we are now saying, time come for ratification of Convention 191. So we are humbly asking the government to ratify Convention 190. This is the only convention since the ILO 100 years. This convention is not specific to one group. It covers formal, informal, private, urban, rural, all sectors. We are saying this is a human-centered approach convention. This convention is everybody's business, not some persons. And we are asking you, Minister, please. I did already, and I'm asking you again if you could push for this convention to be ratified. And we are asking you, Minister, March 8, 2021, International Women's Day, if we can get this convention ratified by then. because this is very important. And next year, International Women's Day will be focusing on the issues affecting persons in the workplace. We know Jamaica is a trendsetter across the Caribbean. Let us set the example across the world. Thank you very much. Let us set the example. Let us be the first person to ratify this convention. The convention provides the possibility of forging a future of work based on the dignity, respect, free from violence and harassment, including gender-based violence. There is simply no excuse for not ratifying this convention. None. Violence and harassment are unacceptable at any place of work or anywhere else. We urge the government to please ratify Convention 190. Thank you very much.
Thank you, Madam President, the Jamaica Household Workers Union. I will ask Mrs. Sharon Coburn Robinson to just give a quick response to the appeal that has just been made. And then Senator Gale will have the opening questions.
Thank you, Madam Chair. Thank you, Ms. Price, for a very comprehensive presentation, and I've heard you. And you've said this over and over. This is not the first time I'm hearing you say this. And the last time you said that, I remember the minister asking me to prepare a brief on this issue. Okay. I remember the minister, or a minister who is chair of this committee, asking that a brief be prepared on the Convention 190, which speaks to violence and harassment in the world of work. And in this very house, when we spoke on the issue relating to, I think it was the presentation that was made by the UE Open Campus, we raised the matter here, and I made a brief presentation on this very issue to indicate that this is something that is the purview of the Ministry of Labour and Social Security, but our minister, being the Minister of Gender Affairs, has asked us to have a liaison with the Ministry of Labour and Social Security, which we have done. So we did the brief, and this was shared, and we've been having the conversations. And so just like you, Ms. Price, we are anxious for the C-190 to be adopted, because this is the only convention that will bring violence and harassment nicely in front of, let's say, on front burner, because it includes issues of gender-based violence and harassment, which is not captured in some of the other legislation. And it picks up where the C-189, that's a decent work agenda, that convention on decent work agenda, leaves off. And so, yes, the minister has expressed her commitment. And so certainly through the Bureau of Gender Affairs, working with the Ministry of Labour, we will push to see how quickly we can get this addressed. Does that respond, Minister?
Yes, I will just indicate here that we are committed to give you a report, maybe at the next meeting of the committee, because this would be recorded in our minutes as a matter that's raised. And at that time, I will be able to give a status report, as we will be requesting that from the Ministry of Labour and Social Security. Awesome. All right, now, Senator Gale, you want to open questions?
Well, it's not really a question, you know, because you run the risk sometimes when you question Shirley Price. But I want to say, I want to commend you for your continuous advocacy on behalf of the group that you represent. I recall last week when you joined our webinar, you took the time out to express your concern around the advocacy of C-190. And again, your consistency, because you were very strong in your advocacy for 189.
Yeah.
And so you are following for the next one, 190.
Yes.
So that demonstrates the extent of your consistency in advocacy, which I believe is commendable. One of the areas that came out in your presentation that highlights in my mind part 3, when you spoke about expanding the scope of the bill, not only to employers, supervisors, and co-workers as perpetrators, but also recognize where I believe the bill doesn't specifically treat it, what I consider third party.
Yeah.
Outside of the control of an employer or those conducting business, but anybody in relation to the operations of whether the household or the organization. So you have recognized that family members, relatives, and friends can be perpetrators, and I consider that as a third party that must be addressed in this piece of legislation. But once again, Shirley, I want to commend you for your level of consistency and the advocacy that you have demonstrated on behalf of those that you represent. You're a true trade unionist.
Thank you very much. Thank you.
Senator Longmore.
Thank you, Chair. Again, thank you for your presentation, Mrs. Price.
Thank you.
Very, very insightful. And my main comment was actually around part 3 that Senator Gale mentioned in terms of the expansion, the very considerate expansion that you have now raised in terms of the other personnel. Yeah. And I would also want to probably expand it further to include other persons who may be working in the same space. So the household helper who may be harassed by the gardener, or by or some other agent of work there too. So that was my main comment regarding the registry. I think that will require some thought because at the same time we have to recognize that persons harassment it is not a criminal or not yet a criminal charge. So a registry is a very permanent step to go to. So I think it is food for thought. Thank you.
Thank you.
Thank you, Senator Longmore. No more questions? Madam, you wish to make a comment, Shirley?
No, I'm okay.
Well, you have done such a great job with your presentation that members, they've just taken in everything that you have said.
Thank you.
And we want to thank you and commend you for the work you have been doing.
Thank you, Minister. Thank you so much.
Right. What I will ask, if you both wish to remain, you could, we're just going to shift the chairs that you were using to bring forward the Soroptimist International of Jamaica. Ms. Maxine Wedderburn, the President, and Ms. Elaine Salmon Brewers. So we will now take the submission, the presentation from the Soroptimist International of Jamaica. Ms. Maxine Wedderburn, President, thank you so much.
Thank you, Madam Chair. I'm wondering how this mouse works. Why is it not moving? I have no idea, so I'll press on. Thank you, Madam Chair, and members of the Joint Select Committee, ladies and gentlemen. it is my absolute pleasure to be here with you today. This is not a foray we have been in much. Is it not on? It's on. Technology. Let's press on.
I'm sorry, we're just gonna. Okay, thank you.
Okay, I was saying this is not a foray we have been much into, this kind of advocacy, although previously we were heavily into it, not able to get it. So I'm Maxine Wedderburn, and I represent today, and I'm speaking on behalf of Soroptimist International of Jamaica. And we also are members of AWOJA. And Soroptimist International of Jamaica, just to put us in perspective so you understand who we are and why we're here. It was the first service club for professional women in Jamaica. And it has been in existence since 1962, the same year of our independence. So we are 58 years old this year, doing service in Jamaica. Soroptimist International is an international volunteer service organization for women in business, management, and the professions. It operates in some 130 countries worldwide, and it actually has a seat at the UN. There are 5 chapters in Jamaica, with clubs operating in Kingston, of which I'm the president of the Kingston Club, in Western Jamaica, Montego Bay area, in Mandeville, in Northern Jamaica, being St. Anne and St. Mary, and in the Mid-Eastern area, being St. Catherine. So those are our 5 chapters. Soroptimist International's mission is to improve life for women and girls by identifying needs and working through targeted service projects to address those needs at local, regional, and international levels. SI, as I'll refer to us here, is a recognized authority on matters that women value most and uses its international voice and official status with the United Nations to advocate on behalf of women's issues. Now, SI would like to address, we finally got it up. Can I have it back then? Can I have the mouse back? No, go back one, and it's not all on the page. It's not all on. Oh, okay, so we're using 2 different, all right, so let's look here. So our mission is to improve the life of women and girls. All right, and we would like to have our input here. It's a delight for us to be here and have a voice on this forum. Okay, some of the things we noticed as we went through the bill, though, that seemed to us to be deficiencies in what exists, is first of all, this matter of sexual harassment in the community and on the streets. Much of what is there speaks to sexual harassment in the workplace and that sort of thing, workplace or tenancy and so. We, though, would like to submit that while the bill aims to address concerns about sexual harassment that are employment-related and occurring in institutions or arising in the landlord and tenant relationship, and sexual harassment at the workplace represents an advance in terms of mandating policies and recognizes a mechanism for reporting, for investigation and punishment for perpetrators. But the Act fails to address the fact that some harassment occurs not at an institution or place of employment, but within communities and on the streets. In this regard, it provides no recourse for men and women who face sexual harassment in the wider society. By profession, I'm a social researcher, and I have sat through so many groups where young people, school children, tell of being afraid to go past the boys on the corner, and they have to wait until so-and-so is coming to walk with them. So these are the kinds of cases that seem to be left out. Pubescent girls and the disabled are particularly vulnerable to sexual harassment on the streets and in their communities. Existing data, in fact, suggests that 1 in 4 Jamaican adolescent girls aged 18 to 19 experience sexual violence in their lifetime. Sexual harassment is a daily occurrence and occurs whether these vulnerable members of our society are walking by themselves or in a group. However, the Act makes no mention of them as far as we see, nor provision for these unattached persons. Students on the way to school, males or females walking on the road, are all potential targets for harassment. In addition to this deficiency, the Act also makes no provision for persons whose living conditions offer little or no privacy. And this is another area I've heard so much about over the years. Providing opportunities for likely predators to monitor these individuals. You know, when the little shower or bathroom area is outside and everybody can look and see what is happening to you. So that could be a prelude to sexual harassment. The fact that an individual may not be operating within a formal work environment should not preclude them from protection under the country's legislation, nor deny them the opportunity to have their complaints heard or to seek redress through the tribunal. This is particularly important since most of our citizens operate in an informal rather than a formal work environment. Okay, so what we're saying here is that we need to widen the scope of the bill to include street and community harassment and send a strong message that sexual harassment of any kind is unacceptable and that persons affected will have some recourse. Okay, our other point. And this one I know has been hotly debated, but we are lending support to it, this matter of the 12-month limit on reporting sexual harassment. This deadline does not allow for the trauma and denial that many victims of sexual harassment, both male and female, endure. Victims of sexual harassment tend not to disclose in a timely manner. They are so traumatized. Research has shown that there are many factors that hamstring the victims and protect the perpetrators. Many victims of sexual harassment often lack the sense of agency to confront the more powerful perpetrator, who may be an influential member in their organization or in the community. For example, where there are area dons who may threaten and pose a real threat to victims and or family members. Again, I've been in many discussions, group discussions, and when they tell me who sent for who, and I say, so what did you do? Their thing is, but me can't do nothing. Me just, because there's no recourse, or we send con kill we. Okay, so we understand that. Some victims deal with the harassment by denial and other psychological gymnastics. Some perform poorly at the workplace and are dysfunctional in relationships until an event or process pushes them to identify the source of their hidden trauma. The reality is that whether the victim is in late adolescence or adulthood, the psychological damage and emotional trauma can be the same. In cases such as we have spoken about here with the pubescent girls, disabled, or community members, the 12-month statute of limitation is quite impractical, where the victims remain living in the same locale and remain vulnerable to the threats of further violence, whether to themselves or their family. They must, as I'm sure you have heard said time and time again, they must wait until their circumstance change, and this may be years later. This crime we submit is not a misdemeanor, and SI Jamaica recommends a time frame of, this may be long, but we say 10 years after discovery, considering the viciousness and persistence of the violation. Definitely not a year. Okay, let's move on to our next point. And that is, we submit that there needs to be a review of the membership of the Sexual Harassment Tribunal. Yeah, man. Oh, no, he skipped one, apparently, yes. Can you go back one? Yes. No. Oh, here now, yes. No, where is number 3? Exhausting internal mechanisms. Let me read from my thing here. Before making complaints to tribunal. Part 2 of the section entitled Prevention of Sexual Harassment maintains that a company's policy statement should include a statement to the effect that, and in quotes, the person who is a victim of sexual harassment shall exhaust all internal mechanisms that are available to the person before making a complaint to the tribunal. Now, we are concerned that since the Act contains no guidelines regarding a time frame for a complaint to be addressed, a perpetrator, especially if in position of authority, either in relation to the complainant or within the organization itself, could see this as an opportunity to drag out the process, thereby frustrating the complainant. There is a similar concern about Section 5(1), relating to the duty of the employer to, in quotes, take immediate and appropriate action to deal with sexual harassment, where the employer becomes aware of the sexual harassment. Both terms are highly subjective and open to interpretation. We believe it would be better to include timelines within which action ought to be taken in order to ensure that complaints are not allowed to languish as they wend their way through the internal mechanisms, thereby preventing the complainant from appearing before the tribunal. The Act does state that an authorized officer, in quotes, on finding out that a person is not in compliance, may determine the time within which the person should comply. But we think that the bill should establish a time frame for action even before the initial act of non-compliance occurs. So we're saying without a timeline, the perpetrator could seize the opportunity to drag out the process, thereby frustrating the complainant. Okay, on to our next point. All right. We're thinking that there should be a review of the membership of the tribunal. And why do we say that? We think serious thought must be given to the composition of membership of the tribunal, requiring balance in every sense, experience, and breadth. Current membership, as outlined in the Act, seems weighted in favor of lawyers. However, the act of sexual harassment is not only a legal matter and may involve psychosocial and other issues. The tribunal should therefore be able to co-opt experts if and when required. This is also the time to consider making a tribunal such as this a traveling one for access, easy access, or to establish a tribunal in individual parishes or within a county. Many persons will suffer or not pursue action owing to the hardships of travel and expenditure should hearings be held only in the corporate area, for example. There would be considerable inconvenience should hearings be put off on a scheduled day, while the person resident in Kingston would merely continue with their day. If this occurs, the person resident in a rural area may have had to get up at 4 in the morning to make it to Kingston on time, and may in fact be losing a day's wage, or have had to incur other expense to set up something for the children and get somebody to stay. This added to the burden of the expenditure of getting to Kingston and getting to the location, securing a meal, and finally the expenditure of the return trip would result in the rural complainant becoming highly dispirited and disappointed, and with a mandate to return on another date with no guarantee that there would not be a repeat of the situation. So let's look at our other point. Our other point. We think there's need for accountability, which we do not see in the bill, and a metric of performance. And we dare say having a tribunal is one thing and is highly creditable, but having a tribunal that performs is another matter. If we are to be first world, we must set clear strategic and operational guidelines and conduct appraisals of our institutions to ensure that they are fulfilling their mandate. The requisite resources must be provided so that the persons appointed can do the best job, and those persons must have proper guidelines as to what is expected of them as optimum performance. We may even have to think in terms of alternates, as too often we find that the busiest persons sit on these tribunals and hearings are delayed owing to a lack of a quorum because persons are off the island or otherwise engaged. We submit that the bill and ultimately the act is important, but we must start looking at effective implementation and accountability. We have to set standards and appraisals be conducted along the way. Our other point, can you change the slide, please? All right, another point we notice as missing, the bill we think should be gender neutral. Now you may say it's implied, but our read of it doesn't show it. There is nothing in the sexual harassment bill to indicate that it will be gender neutral and whether it will protect persons from unwelcome advances from other persons of the same sex. We think it important that all members of the society, including workers and tenants, should be protected from sexual harassment by someone of the same sex. So we think that we must provide protection for all persons. It should apply to all members of the society. And it should not just be implied, it should be stated. Okay, our final point. We know that a huge cause of sexual harassment in Jamaica is attributable to culture and normalization. So often they'll tell me, I just saw it go. I know nothing, I just saw it go. You know, they so become normalized. This requires extensive education to change that thought process and make them understand that even though I just saw it go, that happened to your mother and your grandmother, and no, so it must go. The current draft pays scant attention to this. In our view, the law must authorize and direct funding to an education program to be coordinated by the Bureau of Gender Affairs and the relevant ministry. And I dare say that should start in basic schools up, you know, in HFLE, so they know that, and not so it go. That's not what has to be. Madam Chair, and the members of the Joint Select Committee, it's my pleasure to present to you today and to have a discussion with you on these matters. Thank you.
Thank you so much, Ms. Wedderburn. Ms. Georgette Grant wishes to make a comment or to ask a question.
Thank you, Madam Chair. Ms. Wedderburn, I am seeking clarity on a point that you made, and it's on the issue of the bill being gender neutral. I noticed you said that in your read of the bill, it didn't appear to you to be gender neutral. If you would be so kind to point me to which clauses, because certainly by my reading, it appears to be gender neutral. In the earlier versions of the bill, there were masculine pronouns that were used, and that was one of the reasons why the bill is so specially crafted the way it is now. Any person, any member, any chairperson, any other person staying away from that, because we recognize that this is a bill that is supposed to serve not only females but men as well. So I'm not sure. I want to understand what you mean when you say the bill should be gender neutral. And on the issue of the same sex, based on how the language is crafted in the bill, it does apply to same-sex harassment. Is it that you want a specific line inserted should be gender neutral, as opposed to when you are reading it, you see that it is gender neutral?
No, I think you said initially it said he. It was a masculine pronoun. So it seemed to have progressed. So it seems to have been addressed, I dare say. So we would need to look. So that's wonderful. That's wonderful if you clearly had recognized that and have addressed it.
Thank you. Senator Johnson-Smith, you had a question?
Thank you, Madam Chair. And allow me to just extend my apologies again for having been late. I hope you got the message before and conveyed my apologies to the committee. No disrespect intended, just another one of those days. I wish to commend everyone who has prepared for these presentations to us. Both the presenters who spoke before, I didn't intervene as I came in the middle, but everyone's presentations are clearly very well thought out and very clear in their intent to protect persons who are in circumstances of vulnerability, whether that be in landlord and tenant space, within the power dynamic of employment, or indeed at large. And this point, the latter point, I just wish to pick up on because, Madam Chair, you have said it so many times that the space of the committee is an opportunity for education. It is, in fact, the start of the public education process because people listen, sometimes the media reports, etc., so that not only the presentations, but responses and discussions that we have here are a means of sensitizing the public to what the bill intends to do, what it is in fact doing, and what it is not. So right now, for example, we've just confirmed that the version before the committee is gender neutral. It protects both men and women in the space of employment. It has been proposed by yourselves and by other presentations that it be expanded also to deal with other types of sexual harassment. And I think this is one of the areas, and Minister Chuck, I'm not going to put you on the spot, but I'm going to put you on the spot because, because it is quite clear, if there is any point which has been made clear in every presentation to this committee, it is the grave recognition that our girls and our women on our streets suffer from harassment, and the law does not protect them. So it is not intended to be the scope of this bill because this bill, as the memorandum sets out, speaks to that worker relationship and indeed the landlord-tenant. It goes broader than landlord-tenant because, of course, it intends to address more informal circumstances where people seek occupation. You wouldn't want somebody to be able to get out by saying that, well, they don't have no lease with you. It must be once there is vulnerability imposed by the need for accommodation and the ability to grant it. So the language is actually broad because of that, and I think that was the presentation before, if not this one. But that concept of our women and girls needing protection on the road, and I know you want us to be gender neutral, but we know where the majority of the conduct, of the harmful conduct takes place. Scientifically and anecdotally, it is our women and girls who disproportionately suffer harassment. So where we are going from a policy perspective is to have the Offences Against the Persons Act amended to provide for the offense of stalking and harassment. And placing it there will also allow the Cybercrimes Act to recognize cyber stalking and cyber harassment. So that deals with another type of, and then, so we have the sexual harassment, which happens in the work relationship, which requires the tribunal to, as is provided for, in some cases, require re-employment, etc. That type of specific harm that can occur within the employment relationship. But the Offences Against the Persons Act is going to deal with the broader issue of harassment, stalking, and to increase the fines and the penalties, imprisonment penalties for assault as well. Because the person who is vulnerable in their community, there is no there's no sensitive relationship, such as an employment relationship, but there's vulnerability to harm. And therefore, that can only be disincentivized by the penalties, and ensuring, of course, that our police are trained and sensitized to these issues. So, Minister Chuck, we know where the OAPA sits, and I can't ask you to tell us where it is, because that would be the role of the chair. But I want you to know that it's something that we're thinking of. It is something that is distinct from this bill. And it's something that I actually ask advocates who are following the committee, who are engaging with other persons, who are deeply interested in the matters before this committee, that you have those discussions as well, so that the narrative can continue to build, and we can continue to not only to understand where the other gaps may be, because that is something that has to be treated otherwise. And pressure Minister Chuck to get it done as well. Hold on, sir, I'm still on the floor.
Madam Chair, you notice how quiet I've been. But since Minister Johnson is pulling my tongue.
Maybe I haven't recognized you yet, you know.
Madam Chair, Mr. Bailey and I think Ms. Simon are here from the Law Reform Department. And I know that the Law Reform Department does have the OAPA, which Offenses Against the Person Act, which Minister Johnson Smith mentioned, to examine how much more it can be widened, okay, especially to deal with abuses, sexual abuses. But you will appreciate one has to be very careful how much of the sexual harassment that you speak of, which is in this bill, can be carried out and implemented in the community. Okay? Chair, could we ask Mr. Bill, who is here from the Law Reform, to respond? Good.
Nice, Mr. Bailey.
Thank you, Chair, and thank you, Minister, for throwing me under the bus slightly. Let me start off by saying that I think the first thing that we should really appreciate, and it's something that I recall with some pleasure, is that Senator Johnson Smith, many years ago, because of her passion for the rights of women and children, in fact, was the one who submitted a motion in the Senate when she was in opposition at the time, to have a committee to review all of these laws. A lot of them are outdated, inadequate, and ineffective. As a result of that, the Joint Select Committee that dealt with that, of which she was an integral part, issued a report. And it is our task at the Legal Reform Department, we haven't changed our name yet, to provide Minister with a cabinet submission. In fact, we are working on about 3 of them at this point. And it is my hope to get those submissions to the Minister before the end of this month, so that the recommendations of that committee can be actioned by Parliament. In relation to the street harassment, which is something that has been clearly a very painful topic, and has, from the first meeting of this committee, something that has been spoken about, debated, and presented with a great deal of passion and feeling. We have been working on that, and as Minister Johnson Smith indicated, that we are talking about criminal offenses and criminal penalties, and the OPA, the Offense Against the Person Act, would be the more appropriate place for it. And we are in fact working on a raft of things in relation to not just harassment and stalking and cyber stalking and what do you call this again? Revenge porn, upskirting. There are quite a few things in relation that particularly affect women and vulnerable persons. So we hope to get a lot of that to our minister before the end of this month. So that in next year, Parliament will have quite a few things to deal with in terms of the protection of women and children and vulnerable people.
Thank you, Mr. Bailey. That's good news. Senator Johnson-Smith wasn't quite finished, so I'll allow her to continue her brief comments.
Thank you, Madam Chair, and I hope you're not reconsidering my appointment to this committee. But I'm sure we all appreciate the intervention that has just been made. And it's useful for us all to know that the Minister is working on those changes, that there will be broader protection for our women and girls who take the bus, take the taxi, more vulnerable than the others in their communities and in their movement about their daily business, in addition to this bill, which treats with that situation where you are in close proximity to your harasser on a consistent basis, so that it requires that additional care to the process that you use and your ability to ensure that you can be re-employed, etc. I also just wanted, Madam Chair, this is my final point on it, and on the presentation, just to support the perspective that that has been suggested, again, by all who presented today, that the 12-month period be extended. I think we are all agreed. I know Madam Chair has made it quite clear that she will not be signing off on any 12-month in the bill. So, and she will be supported by us all, I'm sure. So the matter is to work out what the period will be, what the best balance will be between employers and employees, between workers and those who head institutions, to ensure that the society functions well. Because I think we're all here not to try to upend society, but to, I know people are uncomfortable with change, but we're here to find the best balance to protect while ensuring, of course, that there are practical solutions to ensuring that work continues in an effective and dignified way. So we assure you that that is being dealt with, and that we will also be looking at how it is that we ensure accountability of our institutions, which is a matter that we take seriously as an administration as a whole. So thank you, Madam Chair, for allowing me to intervene.
Thank you,
Madam
Senator
Chair, can I
Johnson.
just
Please
say,
go ahead.
I just wanted to say I am greatly encouraged, because it's like everything we have here is being addressed. And I look forward, really look forward to the further work by the OAPA by the end of the month, Mr. Smith said. So whatever, I really look forward to that, because that's a serious problem. And thanks for enlightening me on what this is versus that. It was wonderful to have been here. Thank you.
Thank you, President Wedderburn. We were delighted to have you here. Thank you for your contribution. Ms. Wedderburn, I think MP Crawford wants to ask a question or make a comment.
Thank you, Madam Chair. I'm going to be very brief, just to say that I enjoyed your presentation, very useful submissions. What stands out for me most is the need for the public education. Apart from the fact that, of course, sexual harassment is often seen as normalized in our culture, I'm also picking up on the street that a lot of persons are not making a clear distinction between being sexually harassed or an act of, not even just talking, but abuse. Assault. Yes, so persons are not making the distinction. No. So I really support the need for public education. And as Senator Longmore was saying to me, your use of the term, "and so it go." Minister, maybe you could adopt that tagline to launch the campaign. So, "and so it go." Thank you.
Thank you. You're very welcome.
Okay, thank you. Thank you, Member Crawford. So we will just quickly sanitize the chairs and the table as we await the presentation from Women Inc. and AOJA, the Association of Women's Organizations in Jamaica. Representatives present here this afternoon, Ms. Joyce Hewitt, Executive Director of Women Inc., Ms. Joni Gay Corley, Ms. Tatiana Answer, and Ms. Gillian Mason. All four persons are here? Just 3. All right, you may want to introduce yourselves once you take your seats. All right. I see Joyce here, isn't she?
Yes.
So Joyce, the presentations are separate? Or together? But you want to sit here in the middle with us,
Yeah,
please? Just join the team here. And I just want to thank you, Joyce, Hewitt, and the other ladies for coming, Gillian Mason. Right, for coming this afternoon. Right, Miss Ansel, Miss Mason.
Yes.
And Miss Hewitt. Thank you so much.
Thank you too, and afternoon to the committee. So yes, Women Inc. Also representing Awoja is going to talk about our suggestions and recommendations with this proposed Sexual Harassment Act. As you know, it has been a long road, and Women Inc. has been on this road all this time because the need to have an act addressing sexual harassment is very, very important. So I'm going to skip through some of the background, but do want to recognize and we appreciate that the committee is taking this as a very serious and important matter, which is also our purview. We do want to mention that sexual harassment, like all other forms of gender-based violence, is really not about the sexual behavior that is suggested or performed when it occurs, but really is about abuse of power. And so it is the persons who are in financial or social power who choose to take advantage of situations and intimidate persons with less power. So again, we, on behalf of those who have been victimized, we strongly believe it is time for the Parliament of Jamaica to take decisive steps to provide legislation to protect its citizens. In terms of the specific act, we have 3 specific areas that we want to make points about, and we'll also address 2 related elements which are not currently part of the proposed legislation. Before I mention the points, want to acknowledge, as was just mentioned, that all genders can experience sexual harassment. They can be victimized by sexual harassment, but we are also keenly aware that most victims are female. And so for our presentation, the pronouns that we will use will be she and her. The first point I want to raise has to do with the definition of sexual harassment. And so in part 1 of the proposed act, the definition covers the quid pro quo and the hostile environment context. And in particular, we're focused on a hostile environment context, which speaks to unwelcome sexual advances, which have the effect of interfering unreasonably with the work performance of the person to whom the sexual advance is made, or creating an intimidating, offensive, or hostile work environment. Simultaneously, we recognize that the Act seeks to provide protection for persons in institutions such as schools, universities, medical facilities, and general organizational facilities. And we are really glad and commend the developers of this proposed act for going beyond the workplace environment. However, we do have some concern that the hostile environment part of the definition will not adequately cover non-workers in institutions. Such non-workers can have their general performance affected or be forced to engage in an environment which they perceive as hostile due to experiences of harassment. And as an example, we raise the student who is at a college who is harassed by a residential housing manager or some other administrator employed by the college. That student can have her school performance affected or feel unsafe in residential housing and so view it as a hostile environment. We do recognize that the quid pro quo part of the definition may cover such instances, but we are proposing that there be a broadening of the description of work performance or work environment to ensure that such experiences are accommodated.
Thank you, Gillian. And continuing on that,
were bolstered by the comments by Senator Johnson Smith earlier as it relates to the 12 months for the making of a complaint. Our position at Woman Inc. is that ideally the period should be open-ended, but in the spirit of compromise, we propose that the minimum period a complainant should be equal to that of other civil matters under Jamaican law. And we're advocating for this increase for two reasons. Namely, one, the victimized person may need extensive healing time within which to process the experience, to consider her options regarding legal action, and to develop the emotional and psychological skills needed to handle the reporting processes. This healing period alone may take more than 12 months. And the proposed act requires that the institution within which the sexual harassment incident or incidents occurred be given sufficient time to address the matter internally. And in most instances, it will be only after that process has ended that the victimized person would be legally able to make a complaint to the tribunal. And 12 months is unlikely to be sufficient time for both the healing period mentioned above and for the institutional internal process to be completed. Now, as it relates to Section 34(1)(b) Part 3, the section of the proposed act addresses the possible outcomes of a tribunal hearing and speaks to the possibility that an employer may be directed to employ or re-employ the complainant. We urge the committee and their legal support team to develop mechanisms which will provide protection for the complainant, since working or returning to work for an employer found to contravene the act may result in retaliatory behavior against the complainant. Now, to speak on the first element that we'd like to add, which we didn't notice in the proposed act, repeat respondents in tribunal judgments, persons who engage in sexual harassment and or who develop environments supportive of sexual harassment, they typically engage in such behavior consistently and repeatedly. So for this reason, we think the act should include guidelines of how the tribunal will treat repeat respondents found culpable in tribunal hearings. This would include individuals against whom complaints are made and employers or the institutional leadership whose workplace or institution has multiple complaints made against it. In this case, the employer or institutional leadership could be viewed as not being sufficiently engaged in making their institution one where sexual harassment is not tolerated, despite the stipulations as presented in Part 2, 4, 5, and Sections 4, 5, and 6 in the proposed act. So we propose that a minimum number be established whereby successful complaints lodged to the tribunal within a particular time frame against the same individual respondent or employer or institutional leadership would automatically trigger a second layer of investigation of that respondent with commensurate action, if needed, by the tribunal.
Okay. So our final point that we want to raise is something that was just being discussed, and that is the issue of sexual harassment in public spaces. And we note the proposed plans and welcome the proposed plans to address this. So as has been indicated by others, sexual harassment is extremely serious, and sexual harassment can occur in any location, and anecdotally and documented data do indicate that Jamaicans of all ages and gender consistently face street harassment. Women Inc., of course, also believes that sexual harassment is a significant problem which needs consistent and comprehensive attention. And our social media campaign last year for the 16 Days of Activism actually focused on this issue. So in spirit, we do agree that legislation is needed to attend to street harassment, but we recognize that perhaps there needs to be a two-phased approach to tackle sexual harassment, and it may be a more practical way to go. We recognize, of course, that since coming here that there are other plans afoot. And so in the first phase, we think that addressing sexual harassment in controlled environments as covered by the proposed act would be addressed, and then after that has gained some traction, a second phase could be introduced where the legislation to address street harassment is developed. We hope that the introduction of legislation for controlled spaces will provide the opportunity for the development of effective response systems, and the learning from those effective response systems would also be therefore useful in identifying appropriate systems for handling street harassment. As has been mentioned by other presenters and committee members, the occurrence of sexual harassment has a cultural component. So there are several Jamaican social and cultural beliefs and practices which allow harassers to feel safe to engage in their offensive behavior. For this proposed act to be successful in reducing the incidence of sexual harassment, it will be necessary for these beliefs and practices to be examined, dissected, and ultimately changed. One of the possible consequences of introducing sexual harassment legislation for work and institutional spaces is that the culture within such spaces will change to ones where harassment is not tolerated. There is a further possibility that such social and cultural changes will go beyond the walls of these institutions and result in behavioral change and ultimately a decrease in sexual harassment incidents. Since this latter possibility of having this decrease in sexual harassment incidents is not a guarantee, it is imperative that the Parliament at some point actively develop legislation to tackle street harassment. We also want to know that given our deeply embedded Jamaican practices, which normal sexually harassing behaviors, the introduction of any legislation should be accompanied by public awareness and education campaigns, as has been mentioned by others, whereby these cultural norms are challenged and the implications of the act are discussed. So in closing, we advocate for and implore this committee to act quickly and thoroughly in conducting its deliberations. We hope you will adopt our suggestions as presented and put your full efforts into developing effective legislation to address sexual harassment. We have the strongest conviction that this time, our efforts, along with those from other civil society organizations, will bear fruit. You do have the power to confront this major social ill head-on. We urge you to grasp this opportunity and act speedily on behalf of all of Jamaica.
Thank you for your presentation. I will now ask Senator Gale. I know you wanted to.
Thanks, Chair. So we can add up the percentage by now, how many groups would have appeared before this committee and would have spoken about tackling harassment in the public space, which is, it is very glaring based on the submissions, and we commend the groups for continuing to advocate for some action to be taken in relation to that. In terms of your presentation, Part 6, 34(1) of the legislation that speaks to the award of the tribunal. And, last week, the point about employ or re-employ the complainant, and I want to deal with it separately, because last week I raised the concern that was expressed to me by an employer in that you have a job applicant who might present themselves and there may have been an allegation around sexual harassment in relation to the recruitment process. And that matter may end up before a tribunal. And for the tribunal to award employment when, in the first instance, that applicant may not have been the most suitable candidate. So it presents somewhat of a conundrum. And it is going to be an awesome responsibility on those representing the complainant to advocate that case. True. And I myself, as an advocate, who would be in instances on the one hand representing a complainant in a workplace, and on the other hand may very well represent an alleged perpetrator in wearing two hats, is going to find that challenge. So that's something that we're going to have to deal with in the scope of this legislation, possibly. The re-employment now of the complainant, where, you know, you're urging some sort of a mechanism to be in place, where the tribunal makes an award for the protection, and, you know, the industrial dispute tribunal does that, in that it makes an award in protection of securing the terms and conditions of employment, and anything that employee would have lost. And I can accept the fact that there can be possible retaliation going back to that workplace. So I believe this is a good point. In where you now mention the tribunal treats with respondents found culpable, especially against, so I can understand repeat offenders. And you may have repeat offenders ending up at a tribunal. Now, where you indicate multiple complaints of a workplace, now, you may have a workplace with thousands of employees, and no employer, notwithstanding the best prescribed policy that should be adhered to, can protect against an alleged perpetrator. And there might be numerous now, because you have a legislation that seeks to protect and prevent. You might have numerous persons feeling the confidence to come forward. Right. Now, are you going to place a burden on that employer in terms of how the tribunal will treat with them? Because there's a confidence now, because of a legislation, to come forward. So it's something that we may want to consider in terms of the approach. What would be good is that we must ensure that businesses put in place policies to ensure that there are effective procedures in dealing with complaints, and that they are addressed within reasonable time. So, Chair, those would have been my initial concerns.
Okay.
Go ahead, Ms. Mason.
Yeah. Right. Well, I'll address the first point. I completely understand in terms of employment and re-employment. And actually, for both suggestions or proposals, what we're really talking about is ensuring that a tribunal or the bill recognize these possibilities and hopefully put in place some mechanisms to address it. So I'm not a labor person, so I'm sure that, you know, as we said, we have the IDT, which already has its systems in place, and so that, I guess, could be applied here as well, as long as it's recognized. In regard to the issue of the repeat culpable respondents, again, it is to ensure that that the tribunal has this tracking system so they can recognize. So even if it does turn out, as you said, in an organization with thousands of workers, there are incidents from, you know, various places, those would be unearthed by that analysis. But what is important is that the documentation be done so that at least it can be picked up if there is this issue happening.
You want the tribunal to be able to say, "You again?"
Exactly. Exactly. Yes.
Thank you. Any further questions from the members here? Mrs. Coburn-Robinson, could you go ahead?
Thank you, Minister, Madam Chair. I just wanted to indicate that this was raised last week when we had a presentation from the Bureau about the work we've been doing on public education and sensitization and awareness raising on the issue of sexual harassment. And I remember pointing out that in terms of employing, re-employing, if it is that the person was wrongfully dismissed, or employ if there was a allegation or a complaint that the person was not employed because of an overture of sexual harassment that was not acceded to. I remember saying that in terms of the authorized officers, the bill in Part 4 speaks to the designation of authorized officer, where it states in Section 10(1), the minister with responsibility for gender affairs may designate persons, being field officers, attached to the Bureau of Gender Affairs. Now, this has been debated here, where it has been suggested the name not be mentioned as the organization, just in case we have a name changed, as authorized officers for the purposes of 1, investigating and securing the proper observance of Sections 3 and 4, and investigating any complaint made under this Act. So I remember saying last week that if it is that it's a case where the person had gone through the recruitment process, then there would have been a series of processes that would have been observed for the recruitment process to take place. So there would have been a short listing, there would have been an interview process with a panel, and that panel should have been balanced, because that is what most of the, all HR practitioners have been observing, that, the balance. So, for example, if you have on your short list 3 males and a female, that each of the candidates would have at least 1 female and a male on the panel. So it's not an all-female panel or an all-male panel. And the recruiters, the persons who are part of the recruitment process, would have had their rubric in terms of how they assess each of the candidates who are coming. And at the end of it, there would have been a very objective process in terms of the written statements coming out of the interview by the panelists, as well as the scores that would have been garnered by the interviewees. And at the end of that, they would have discussed it and arrived at the person who was. What I'm saying is, if it is that a claim is made, then there is a record and there is empirical data and evidence that can be brought forward to indicate that, yes, this person would have gone through the process and was the most qualified or not. And so, as we had said last week, I don't think, and I'm sure, that the bill does not make provision for a willy-nilly selection based on the fact that you are alleging that you did not get the job because of sexual harassment. There are provisions in this bill for the investigation to be done, for the evidence to be presented and provided, so that there is absolutely no doubt that the award is a fair one. Does that respond to your question?
Well, that I think is more in line with the decision by the tribunal. What we're really focused on is what happened. So the authorizing officers do their investigations and determine that, okay, this person really was on paper the one to be selected. But what happens when that person turns up for work, right? Will they then, having had this experience, this initial experience with their employer or an agent of the employer, what will then happen to them when they're on the job? So what you're describing, it sounds really good for ensuring that the tribunal's decision has the supporting evidence, but whether it will provide protection once a person starts working there, that is what we are querying, is what we're addressing.
So if I may,
go ahead, Mrs.
To the chair, in terms of how it happens once a person gets on the job. So initially there is an orientation period, and the orientation period would allow for orientation that allows for matters such as those to be addressed. For example, the Bureau has been doing sensitization on sexual harassment and a number of other issues relating to gender-based violence during the orientation periods. The HR, they have that responsibility to ensure that matters relating to workers' rights and how is it that persons see what it is that they are allowed to do, and in terms of how it is upheld and what is allowed and what is not allowed. For each institution, there should have been a policy statement or a policy itself. In the absence of that, there is a grievance procedure. And certainly, if no grievance procedure exists, then there is something in the staff orders that guides the public service that would allow for that matter to be raised. So the person who becomes an employee in that space has that recourse if it is that the person feels uncomfortable or feels as if they are having, perhaps they're starting off on a shaky footing and they're just not really sure of how to to get around what it is that is happening. Because yes, it would be uncomfortable if the person who employed you is your boss and you have to deal with the person, to see this person all the time, knowing that this person perhaps made a sexual overture to you and you rejected it. So there is a way to deal with it. And of course, because the tribunal is within the ministry and the Bureau of Gender Affairs is that entity that is secretarial to the tribunal, then there is scope for support. So once a person makes that complaint or just raises the issue, there is support, psychosocial support, that can be provided to such a person.
Okay. That's good to hear.
Sorry. Senator Gale?
You know, I triggered the discussion for various reasons. And the discussion ensued with a presumption that a lot of these organizations will have some big established policies operating. That's not so. Let's agree and understand that there are going to be some small entities that don't have these provisions in place around sound HR policies that can be represented as evidence before a tribunal. And what it tells us is that we may have to develop, spoke about a code of conduct that would supplement this legislation, or maybe even schedules that have some prescribed formats where businesses can follow in order to protect themselves against some of the provisions that are contained in this legislation. So we know the objectives that we're trying to achieve. And one of the things that I've always grappled with in terms of passing a legislation on a Friday here is how that legislation actually works after that. And what are some of those functional mechanisms that the governing ministry has to put in place to ensure that these legislations actually work. And the group that presented before actually spoke about those performance-based metrics to ensure that the legislations will be effective. And that is something that we're going to have to deal with, having placed this legislation on the books to ensure that it operates as effective and as practicable as possible. So, over to the three ministers that are here.
Yes. Well, I think Mrs. Robinson may want to make an input in this regard, because I think the Bureau would provide some support to small entities to develop policy document, to provide guidelines, and to work with. I know, for example, Danny Roberts has offered to work with us, to assist in this regard as well. So, Mrs. Robinson?
Thank you again, Madam Chair. So, in terms of the templates for sexual harassment, because of the fact that this issue has been on the books for a while, from as early as 2004, we had our first sets of consultations and so on. Womaning, for example, has been a part of the conversation from very, very early. Gillian, Joyce, and Titania earlier, like perhaps came on later. But the conversations have been ongoing and very intense. And so we would have had templates that we would, very simple templates, that we would have been sharing with persons through the sensitization sessions we have. We also have gender focal points, and these are responsibility centers or persons who we consider as focal points, appointed within their space as these officers who are the go-to persons. For example, they are the watchdogs, for want of a better word, meaning they are the advocates in their space in terms of what happens where gender is concerned, to make sure that if a policy has been developed, a plan or project has been rolled out, that it has a gender dimension and that there's balance and there's no discrimination and no one is left behind. And so we have developed templates that are very easy to use and very easy to share and perhaps to be used in this space, because not every workplace is going to be having the same type of experience, and no template is going to be homogeneous. So what we've done is to tweak it so that it's easy enough for persons to insert what it is that will be matching their particular space. For example, the UDC. The UDC's policy is very unique because they have parks, recreational parks, where persons are exposed significantly to harassment. That's their employees. And so their particular policy is a little different to persons who are just within the space, the four walls. And so what we advise persons to do is to make sure that the nuances are captured in your bill. There is also in your policy, rather. There's also the anti-sexual harassment bill, the anti-sexual harassment policy, rather, that was developed very early when we had these consultations, and it had folded in some of the very ideas that persons had in terms of how it is that sexual harassment should be defined, how it should be constituted, what forms of redress should exist, where should persons go. And that is where we had the first discussion around how should the tribunal look. Should it be ad hoc, just convene when required, or should it be permanent based on the gravity of the offenses, the number of cases, and how frequently we believe persons will bring cases before the tribunal. And so we have had a lot of changes made to this particular legislation since we started. The 2015, if you do a comparison, it's a number of changes that have been made, and that has been because of the number of consultations we've had, the fact that we've had the Joint Select, more than one sittings of the Joint Select, sets of Joint Select committees, where persons have come in with very solid arguments in terms of how they believe we should nuance the bill, and that has been incorporated. So what you're seeing today is a far cry from what existed in the first one, and it has lots of improvements. So persons do have recourse, and there is scope provided for support. There are, because we took the legislation from the CARICOM model bill, you can, if you go online, for example, you will see that most of the other countries that have developed their legislation, it's not far-fetched from what we have here, because we have also looked at other legislation. Mr. Maurice Bailey is here with his team. We would have looked at comparative and companion legislation from Caribbean, from other countries in the global arena, and we have looked at how it is that they have nuanced their legislation, and how it is that they have allowed persons to, for example, develop their own policy, which is so very critical. And finally, the bill states that every responsible person has that responsibility to make sure that there is a clear policy within that space that speaks to how is it that the workplace will treat with sexual harassment. How is it that the complaints will be heard? What sort of redress will be taken, and what's available to workers, and how can they access that? And of course, because we don't exist in a silo, there are conversation parts between and among entities. And I did mention the Gender Focal Point Network. There's also now a Gender Advisory Council that was adopted, or the appointment took place in 2018, and that Gender Advisory Council allows members. Mrs. Hewitt, who is here, is a member of the Gender Advisory Council. Ms. Shirley Price, is a member of the Gender Advisory Council, and that council allows for oversight for the two major documents that the Bureau pushes out. That's the National Policy for Gender Equality, which references this particular legislation and recommended the legislation, as well as the National Strategic Action Plan to eliminate gender-based violence, the NSAP, which is called NSAP for short, which speaks definitively about ensuring that sexual harassment does not take place. And that is why the C-190 is so critical, because it dovetails into what the NSAP speaks about ensuring that there is no harassment and any form of violation of persons' rights within a space or a context. Does that respond adequately?
Thank you, Mrs. Robinson. And just to re-emphasize here that the Bureau of Gender Affairs is available to provide support and technical assistance in entities developing the sexual harassment policy.
Good to hear.
Yeah. All right. So, Ms. Mason, Ms. Answer, Mrs. Hewitt, I thank you so much for your presentation.
Thank you, too.
And
thank you,
we certainly will take on board the points you have raised. Feel free to leave or to stay. We're about to end our committee meeting for this afternoon. I just want to thank the presenters, the members, and the technical team, and to ask if there's no other business. Can someone so move?
Madam Chair, before you move for the adjournment, I have an apology, however late, for Member Tamika Davis.
Now, I should mention here that Jamaicans for Justice was scheduled to make a presentation. And unfortunately, they have not been able to make it this afternoon. We did get a message that they were not able to make it. We will have further discussions with them if they are withdrawing their submission or if they will be available for the next meeting. So again, thank you. You wanted?
Any more meetings for the rest of the calendar year?
Well, we have up to the 10th.
Okay.
But we can make the decision this afternoon if we want a break. There are other presentations.
I think in that case, Madam Chairman, I don't see any need to meet.
So if we close off
right.
for this year, leading into the Christmas holidays, make this our last meeting.
Exactly. No, before you close, though, Madam Chairman, we should ask that the report be put together for sometime early next year. The matrix. So
the matrix is being put together, which will be sent to members. We were hoping we'd have a meeting on the 10th, but we now have all the presentations in, except for Jamaicans for Justice.
But will the matrix be ready for the 10th? No. So in that case, there's no need to meet, Madam Chairman. My suggestion is that we meet, early next year to look at the matrix, to confirm all the minutes, and then hopefully give the Secretary enough time to prepare the report. Yeah.
Chair, just to say, procedurally, so JFJ would have made a very elaborate submission. And you see, we have to determine how we treat with that submission, because if you make such a submissions and you are invited and you accepted the invitation, you don't want it to be said that you never got a chance to present. So they would have to confirm that we can consider it. And also for the purposes of the matrix, there would have been some individuals who would have made statements, and I'm suggesting for the record that the matrix take those into consideration also, so that all submissions would have been captured.
That we recognize the submission that has been sent in, we include it in the matrix, although they were not able to come and make a presentation. And so we will treat it as Jamaicans for Justice making their input into the deliberations here through their submission. So in saying that, it means then it would not be necessary for us to meet for the rest of the year, and that as soon as the matrix is completed, we can schedule our next meeting. We really intend to take the act to Parliament before the end of the fiscal year.
If I may, Madam Chair, if this is proposed to be the last meeting of the committee, I wouldn't want the next time that the committee meets that it would, my absence would be noted. I'm afraid the clock is ticking on me, and so I believe I'm supposed to be off on pre-retirement leave. So the next time you see me, I'm not likely to be occupying the position that I do at this point in time. So I wish to just convey my departure comments to be a privilege and an honor to serve. I'm afraid that's a function of law, Senator. The Pensions Act requires that I do depart. So depart I will. My post has already been advertised, so as I said, the committee know that there are other capable persons in my department. Ms. Simon is here, and there will be others who will be attending to the needs of the committee. So thank you very much, and I wish this committee well.
Well, Mr. Bailey, we're going to miss you. You're too young to retire. I would ask the members and everyone to applaud him for his service and his contribution. I'm sure we'll see you again, however, in one way or the other. Thank you so much. So, at this point, I think that I will ask for someone to so move. Move. So when the second is okay, moved by Minister Chalk and seconded by I'll ask the secretary to determine whose hand was held up first. Or maybe Mr. Sibley's, right? Okay. So thank you so much.
Minister, date to be set?
No. You will be advised of the date of the next meeting. And I wish all of you a Merry Christmas and a COVID-free period of enjoyment over the holidays. Keep safe. Thank you all. Bye.